Hi, everyone, and thank you for joining today's webinar, the NLRB Today, What Every Employer Should Know. The NLRB is constantly in the news, from the Wall Street Journal and National Law Review writing articles as recent as yesterday, to the President of the United States pledging himself as a union president. Today's presentation topic will provide you with deep insights on the current state of the union's organizing and what employers should be doing about it. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization, ComplianceHR. My name is Stephanie Zielinski, and I'm the Marketing Director for ComplianceHR. You may recognize my name because I am the point of contact for all joint Littler and ComplianceHR events, of which there have been many this month. Before introducing my company, I would like to get ahead of most of our most asked questions. Yes, you will be receiving a link that takes you to the recording of this presentation and a downloadable version of the slide deck in an email from ComplianceHR webinars within the next few days. If you are seeking SHRM or CLE credit for this presentation, you will need to remain on the meeting for at least 60 minutes, and a certificate confirmation will be pushed out to you at the end of the presentation. Additionally, in the links panel, there is a link to a PDF on how to access your certificate. That may be helpful for later. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, NYOTA and Littler Mendelson. ComplianceHR delivers expert employment law guidance in a fraction of the time by leveraging Littler's employment law information and NYOTA's technology. Our goal is to simplify the complexity of employment law for HR and inside counsel teams. To achieve this goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics, like employee overtime, independent contractor classification, onboarding and leave documents, and the topic I'll focus on today, employee handbooks. An updated and compliant employee handbook is essential for the reasons listed on your screen. Get a jump start on compiling this incredibly robust content with our PolicySmart solution. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance timeline, handbook checklists, and even sends you automated emails to alert you on new legal changes that are going into effect. Once you select your jurisdiction-specific content, you can even export it into an easy-to-edit Word document, and that way you can add branding or cultural initiatives. Now, I'm going to go ahead and launch a poll. If you're interested in learning more, a survey should pop up on your screen. If you're in full screen mode, you will need to exit full screen mode to reply to this poll. To have a custom demonstration, simply answer yes, and I will send your contact information to our team of experts to have a deeper conversation with you about your compliance strategy and how ComplianceHR can support it. In addition to a demonstration of our solutions, you'll also receive a 1-week free trial of our products. That way, you can see precisely how much time and money they will save you. If you're not sure at this time, don't worry. We'll likely push the survey out once again before the end of the presentation. You can also request more information via the Q&A box or visit the links panel. All right. Now, I have the pleasure today of announcing our presenter, Michelle Devlin. Michelle represents management in labor and employment matters, including labor management relations, under the National Labor Relations Act, making her an expert on today's topic. Michelle, I will go ahead and pass it over to you for today's presentation.
Thank you, Stephanie. We have a very robust agenda today, so let's get started. Today, we're going to be talking about organizing trends, risk factors, and proactive steps that your organization can take in regards to organizing activity. We're going to be talking about the Biden NLRB and the General Counsel, Abruzzo, and their initiatives. We're going to be talking about major NLRB decisions affecting unionized and non-unionized employers alike, and what's next for the NLRB. As Stephanie mentioned, the board has been quite active. But today, we're going to be focused on activity and decisions that are of interest to both unionized and non-unionized employers alike. Let's get started. Organizing trends. Anyone who's followed the legal news knows that unions have been in the news quite a bit since the pandemic, and in particular last year and continuing. However, for the past several decades, business has not been very good for unions. The rate of unionization in the US has declined since the 1950s, down to an overall rate of just 10.8 in 2020. And I point out here on this slide that for the private sector, so excluding your public employers, municipal, state, federal, police, fire, school boards and the like, in the private sector, unionization for 2022 is at just 6%, and that declined again slightly from last year. So, as I said, business has not been particularly good for unions in the past several decades. However, it appears that that tide has been turning somewhat. A Gallup poll showed that support for labor unions is at its highest level in over half a century. As well, for fiscal year 2022, union representation petitions, so petitions filed for the purpose of organizing employees, were up 53% since fiscal year 2021. And as well, unfair labor practice charges filed with the board increased by nearly 20%. And what we also saw in connection with that 53% increase was that unionization was happening in industries that were not traditionally organized. Grocery chains, fast food, retail, technology, cannabis, financial sector. So what this showed us is that employers in any industry were seemingly vulnerable to union organizing. And what gives? What gives for this surge in union organizing? What are some of the reasons why we think this occurred? Well, there were many factors that contributed to the flurry of union organizing during the pandemic and through till today. Of course, most notably, the COVID-19 pandemic created immense fear and uncertainty among workers, particularly frontline workers who are in safety-sensitive positions. Among essential workers, were concerned about safety and maintaining their jobs. At the end of 2021, we saw the Great Resignation, which shifted the balance of power somewhat between employees and employers who were hard pressed to find labor to run their businesses. As well, unions were aligning themselves with social justice issues, particularly race-related issues, the George Floyd movement. Unions were supporting the social justice movement that we saw. As well, we have Gen Z in the workplace who appear to have an affiliation for movements and causes, including unionization. We have rising inflation, bringing uncertainty to workers, the Biden administration's pro-union stance, which we'll talk about more. And we also had the prevalence during the pandemic of mail ballot elections, which changed the dynamic a little bit when it came to union elections and seemed to give unions an advantage in elections in certain ways. So a lot of factors that contributed to an upsurge in union organizing. As well, we had the rise of virtual organizing, making it easier to organize employees. Many workers since the pandemic have been working from home. Virtual organizing is a low cost and effective means for unions to reach a mass audience quickly, especially these remote workers. And we saw that virtual organizing was sort of capitalizing on these social distancing type fears during the pandemic. Unions were creating websites to educate workers on their rights more than they were in the past, virtually recruiting labor leaders and activists, texting, QCR codes were available for organizing purposes, the creation of union-specific apps and sites such as Union Connect and coworker.org, podcasts, webcasts, etc., for the purposes of union organizing. As well, we saw a rise in what's called inside-out organizing. Traditionally, it was outside-in organizing. A traditional labor union, Teamsters, SEIU, for example, would work with a couple of employees to drive the union campaign more from the union side, from the outside. Now what we're seeing more is that employee organizers inside the organization are driving campaigns, sometimes with the backing of traditional unions and sometimes not, through methods such as, I said, virtual organizing, social media, the support of labor-friendly politicians, and SALTs. What are SALTs? SALTs are paid union organizers who apply for jobs with an organization specifically for the purpose of organizing that organization. And that's legal according to the board. And SALTs are nothing new. We've seen this in the past for decades, but we saw more coverage, at least in the media, with respect to SALTs organizing some household name corporations in the past couple of years. We're also seeing sympathetic supervisors, supervisors who are sympathetic to the unionization movement of some employees. Perhaps they were recently promoted and they still feel aligned with employees. Many of the supervisors are millennials and Gen Xers who likely don't know the consequences of union organization and the impact that it has on their work lives and their interactions with employees, because as I mentioned, unionization has declined for many decades. So they really don't understand the impact. They didn't see their parents in unions, probably because of that decline in unionization rate. They don't really understand the impact of unionization. As well, they may have very well experienced the same pandemic difficulties that their reports experienced. And what this has all shown is that really any employer is vulnerable to union organizing now, particularly your more brand conscious employers that have a number of Gen Z workers and remote workers in really any industry. That's what we've seen over the past couple of years. So what can your organization do now? Well, first of all, I would advise to put the stats in perspective and really not panic and take a breath. Although we're seeing this trend in support, rising support for unions, that same Gallup poll showed that the majority of employers, 58%, said they were not interested at all in joining a union. So maybe they support it for one reason or another, but may not be interested themselves in joining a union. As well, keep in mind that the unionization rate is still historically low. So, my colleagues and I are of the belief that although we have seen this rise in union organizing, much of it is more headline in fact, as well, considering that the vast percentage of those petitions that came in the end of 2001, 2002 were mostly to organize one particular chain that I'm sure you've seen in the news. So putting that all in perspective, while there was an increase in union organizing, it's really not cause for panic. That said, more employers are vulnerable now. So what can you do? Well, I would suggest that you define your organization before a union defines it for you. what does your organization stand for? What's the position on unions? And has that been clearly communicated to employees? As well, it's more important than ever to train management in maintaining an issue-free workplace, because unionization, the unionization movement can seize on any particular issue in a workplace. And we've seen that when a campaign starts, it can really spread like wildfire. So it's important to train management in preventing and spotting issues that can lead employees to seek assistance from a third party, a union. As well, it's suggested that employees develop a campaign plan. What we saw many times is that when these campaigns hit, they spread very quickly, and the employers were not prepared in the sense of what their position was going to be in that campaign, which of their management personnel were going to handle different aspects of the campaign, such as employee communications, interaction with the media, who was going to be in charge of training supervisors, training the employees, things like that. So it's suggested that an organization, well before the word union is ever heard in the workplace, develop this kind of campaign plan to pull out and be ready in the event of a campaign where it can be used most meaningfully. Let's talk about the Biden administration agenda and the NLRB. Now, when President Biden came into office, he pledged to be the strongest labor president that you've ever had. He said he's a union president and made no bones about that, and has taken steps to be consistent with that characterization. He's supported the PRO Act, which is back on the table for 2023, has many, it would change many aspects of the NLRA in a way that would make it easier to unionize employees. I won't get into the PRO Act in this presentation. As well, Biden supported the Build Back Better Act, which had several union-friendly provisions, such as a tax rebate for union-made electric vehicles, among others. And what a president does that can be really significant in terms of labor policy is the appointments that are made to the NLRB. The NLRB currently has a Democratic majority. The members are shown here. We have the Republican appointee, Marvin Kaplan, in the minority. And as well, Biden terminated the general counsel to the NLRB, Peter Robb, from the Trump administration and appointed Jennifer Abruzzo, who I'm sure you've seen in the news. She's had a long career at the NLRB. She most recently, to her appointment, was special counsel for strategic initiatives at CWA union. And when she came into the office, she wasted no time in furthering her agenda to support unions. She ratified the actions of the acting general counsel Peter Sangor, I'll talk about it in a moment, and issued several guidance memorandum outlining a robust agenda to overturn Trump board decisions and others. Just a quick quote here from an Abruzzo tweet. She said, "It's so important that we utilize every possible tool we have to ensure that those wronged by unlawful conduct obtain true justice." So it gives you a flavor of the general counsel's mission. I won't get into every memo that the GC has issued because that would be a very, very long presentation, but I want to highlight a couple that are of interest to employers who are either non-unionized or unionized. And one of them is a memo by acting General Counsel Peter Sung Orr on vigorous enforcement of protected concerted activity. Now, firstly, what is protected concerted activity? Well, it stems from Section 7 of the National Labor Relations Act, which gives employees the right to self-organization, to form, join, or assist a labor organization, to bargain collectively through representatives of their own choosing, and to engage in other protected activity for mutual aid or protection, or to refrain, in other words, not engage in any of the activities. And really, Section 7, when it comes to employee rights, is the heart of the National Labor Relations Act. Now, all employees have Section 7 rights, not just unionized employees. Non-unionized employees have Section 7 rights as well. And we see many unfair labor practice charges filed by non-unionized individuals claiming often that they've been retaliated against in some way for the exercise of their Section 7 protected concerted activity, their Section 7 rights. And what we see through this memo and other actions of General Counsel Abruzzo is a very expansive view taken of what protected concerted activity means. In many cases, it includes political, in her opinion, political and social justice advocacy, even when that activity is not clearly, explicitly connected to that employee's workplace, or concerted in the way that we've seen it in the past, meaning concerted, meaning joining with other employees of that workplace. An example in this memo being a solo, quote, solo strike by a pizza shop employee to attend a Fight for 15 demonstration. In their view, and how they would urge the board to rule, is that that would be considered protected concerted activity as well, or indicated, and GC Abruzzo ratified for the rescission of the Boeing decision regarding employer policies and handbook policies. We'll talk about that a little bit more, signaling a return to the Obama era war on handbooks. So all this to say that this administration takes an expansive view of protected concerted activity, and that affects all workplaces. As well, Abruzzo issued, when she first took office, a very aggressive hit list, meaning a list of precedents from the Trump board that she would urge the board to overturn. And we'll talk about some of those that the board has already tackled and that are on deck. Again, those affecting all workplaces, unionized and non-unionized. All right, let's talk about some key NLRB decisions that have already issued, again, affecting both unionized and non-unionized workplaces. Firstly, the return of micro units. Now, let me start by saying that when a union petition is filed with the NLRB, the unit, the bargaining unit that the union petitions for, has to be what's called an appropriate unit. It's a legal term, appropriate unit. And what that generally means is that the employees in that unit share what's called a community of interest based on several factors, such as shared supervision, their functional integration, sharing terms and conditions of employment, and other factors. A decision was issued late last year called American Steel Construction, and it returned to an Obama era standard for determining what is an appropriate unit in what was called specialty healthcare. As long as the union's petition for bargaining unit consists of a clearly identifiable group of employees who share this community of interest, the board will presume that the unit is appropriate. And if the employer claims that the appropriate unit should include other employees than the union wishes to include, a bigger unit, in other words, the burden is on the employer to show that the petition for union is inappropriate by demonstrating that the excluded workers not only have a community of interest with those workers that the employer wishes to include, but shares an overwhelming community of interest with those workers. So a higher standard for the employer to demonstrate that other workers should be in that unit for it to be appropriate. It should be a bigger unit. And what this all means is that it will be easier, we expect it will be easier for unions to organize smaller segments of the workforce, smaller units than it could under the traditional standard. And that's important because traditionally unions prevail more the smaller the bargaining unit. When you get to larger bargaining units, employers statistically tend to prevail more. So the smaller the unit, the more likely it is that the union will prevail in the union election. And what it means is that any business is vulnerable to this micro unit type organizing. So it's possible that the union can target a particular shift, a particular department or a segment of the department, a single department in a retail store, for example, and seize on a particular issue that those employees are concerned about in their workplace and use that issue as a basis for organizing that smaller segment of employees. Again, makes for easier organizing for unions. And it makes it all the more important that employers now keep a pulse on the issues that are affecting their employees, because any discrete group can organize around the idea that they have been wronged, and it's easier to do so now under this standard. Another decision that was issued was called Thrive. And in this decision, the board expanded the scope of make-whole remedies available to workers who allege and prevail on unfair labor practice charges. And I mentioned that non-unionized individuals can file such charges based on alleged infringement of their Section 7 rights. Traditionally, the remedies for such violations were reinstatement and back pay. But now the stakes are higher for employers because they're subject essentially to consequential damages. Employees may request that the board hold employer responsible for any direct and foreseeable financial harm they allege to have suffered. And if they have the opportunity to show pecuniary harm versus receipts, invoices, medical bills, credit card late fees, missed mortgage payments and late fees, and the like. And employers can be on the hook for those consequential damages after this Thrive decision. And again, what that means is that the stakes are higher for employers, both because the monetary penalty can be much greater, but also we're expecting there to be a lot of litigation about this issue itself of what harms have become of employees, and protracted compliance litigation on top of the substantive ULP litigation about what employers might be responsible for in terms of consequential damages to employees. An issue I bet that you have been hearing a lot about and are interested to hear about, and that is the McLaren Maycomb decision, where the board recently held that certain provisions, in a separation agreement were unlawful, specifically the confidentiality and non-disparagement provisions in that case. Now, in this case, the NLRB overturned two decisions that had permitted employers to include more robust confidentiality and non-disparagement provisions in severance agreements. And they held that the mere proffer, that is, just giving the employees the agreements to consider, not enforcing it, doesn't matter if the employee signed it, the mere proffer of the severance agreement that conditions receipt of benefits consideration on the forfeiture of Section 7 rights violates the NLRA. Severance agreement is unlawful if its terms have a reasonable tendency to interfere with, restrain, or coerce employees in the exercise of their Section 7 rights. Now, what did these provisions say in the case? Well, I'll paraphrase, the confidentiality agreement at issue basically required employees to keep the agreement confidential, except for tax and legal advisors. And when it came to the non-disparagement provision, it required employees not to make statements to the employer's employees or to the general public, which could disparage or harm the image of the employer, its related entities, and their officers, directors, employers, etc. Now, these are very common provisions in separation agreements. Why did the board find these to be unlawful? Well, according to the board, the provisions at issue had a reasonable tendency to chill former and current employees in the exercise of their Section 7 rights, such as the right to make public statements about their workplace, including negative ones, to assist coworkers or former coworkers with workplace issues, to cooperate in board investigations and litigation, to discuss the terms of the agreement and other workplace matters with current or former coworkers, a union, the board, any government agency, or the media, or to discuss the terms of the agreement with a union. So that's why the board found that these provisions were unlawful, and that merely giving the employees this agreement to consider was itself an unfair labor practice. So there are a number of takeaways from the McLaren decision. And Littler has two publications out now, an Insight and an ASAP, that I would encourage you to check out for a more detailed analysis of the McLaren decision and the General Counsel's guidance that was issued last week on her opinion on the interpretation of the McLaren decision. But I'll give some of these takeaways. Firstly, it doesn't, with a very narrow caveat that the GC made in her recent guidance memo, the decision does not apply to agreements with executives, managers, supervisors, or independent contractors. It's employees and not executives, managers, supervisors, or independent contractors that have Section 7 rights. So agreements with non-employees can continue to have provisions that would be unlawful if they were given to employees, with a very limited exception that's in her guidance memo that Littler's discussed in its publication. As well, the decision is not limited to separation agreements. It was a separation agreement for RIF that was at issue in McLaren. But we expect, and the GC's guidance indicates this, that the same analysis will be applied to other types of employment-related agreements, such as settlements of claims, settlement agreements, employment agreements generally, not just or if you had such provisions in a non-compete or in an invention agreement. Other types of agreements that may have these provisions that may infringe on Section 7 rights are on the chopping block too, not just separation agreements. Not all confidentiality and non-disparagement provisions violate the NLRA. The GC was clear in the recent guidance that employers don't have to outright delete their confidentiality and non-disparagement provisions. She indicated, somewhat vaguely, but did indicate that when it comes to confidentiality of the agreement, it appears to be okay to limit such confidentiality to the amount of the agreement, because the board permits that when it comes to certain settlements of its own ULP charges at the board. So that appears to be lawful. When it comes to the confidentiality of business information, employers can continue, provided it's defined the right way, to keep confidential trade secret information and proprietary information. When it comes to non-disparagement provisions, the GC indicated, and we were expecting, that it would be permitted to basically have a defamation standard, to have a clause that says that the employee cannot make maliciously untrue or false statements about the employer hearkening to that defamation standard, that would survive scrutiny by the board. Really, there's no one-size-fits-all approach here. The approach that the employer takes, and we're seeing employers take a range of approaches here, really depends on the business objectives and what's going on. Is this a RIF? Is this a specific settlement agreement? Is it a separation agreement of one particular employee with certain circumstances? Depends on the business objectives, the culture of that employer, the brand sensitivity, and the legal risk profile and tolerance of that company. Some employers, believing that this decision is going to be appealed and may not survive court scrutiny based on their risk tolerance, are not changing their provisions. Of course, that does subject them to unfair labor practice charges in the meantime, but some employers are taking that approach. Some employers are removing the risky language entirely. Some are revising them in the manners that I just suggested, consistent with board precedent, particularly with Obama board precedent that looked at some of these policies. Or they're including robust disclaimer provisions, disclaimers that say that nothing in this agreement infringes upon the rights of employees to, nothing infringes upon their Section 7 rights and their ability to exercise their Section 7 rights. Some employers are including such disclaimers in one or more places in their agreement in conjunction with revisions of the risky provisions or not. Also consider severability language. That refers to language that would, if the confidentiality and or non-disparagement provisions were found unlawful, to sever those from the rest of the agreement. That might not save it, but it's something to consider. All of this is up for interpretation by further board decisions and courts of appeals. So let's talk about what's next for the NLRB. And again, I'm going to focus on, there are many other areas, as I mentioned, that the GC would like to target in terms of overturning precedents and affecting more policy changes through the rulings of the board. But I'm going to focus on what's on deck that would affect both unionized and non-unionized workplaces. The board has invited briefs, amicus briefs, on several different issues, one of which is the standard for evaluating the lawfulness of work rules in a case called Stericycle. You're probably familiar with what was called the Boeing decision under the Trump board, which made certain policies, employer policies, usually contained in a handbook, categorically lawful. The General Counsel is advocating for the standard that was in place under the Obama board that does not have these categorically lawful rules. Rather, it's a balancing test. And we expect that under this balancing test, as it was under the Obama board, many more employer policies and rules in handbooks that might be found lawful sitting here today under the Boeing standard would not be lawful under the General Counsel's preferred standard. As Stephanie mentioned, it's important to have an updated handbook, and this is one of those reasons that the NLRB is expected to return to a standard that would invalidate many of the rules that are lawful today. That decision has not come down yet, but that's what we're expecting the ruling to be. As well, the board is considering the standard for determining independent contractor status, whether workers should be classified as employees or independent contractors. And why is that important? Well, if a particular worker is classified, properly classified as an employee, as opposed to an independent contractor, that employee now has the full panoply of Section 7 rights, including the right not to have those rights infringed by the employer and the right to unionize So if more workers become classified as employees rather than independent contractors, those workers can now have Section 7 rights and form unions. Under the standard now, it is harder. It's a harder standard for unions to demonstrate that these workers are independent contractors. The General Counsel is advocating, as you expect, for a standard that makes it more likely that workers would be classified as employees and therefore be able to unionize. Also on the table is the status of confidentiality requirements in mandatory arbitration clauses. In a case it's called Ralph's Grocery Company, the board's going to determine whether certain confidentiality requirements, which are common in mandatory arbitration clauses, are lawful or unlawful. And perhaps the McLaren decision is foreshadowing for how the board is going to rule. The General Counsel has also, in at least one case before the board, urged the board to find that captive audience meetings are unlawful. What are captive audience meetings? First of all, I don't like that term because it's negative off the bat, but what it means is when an employer convenes employees in a mandatory meeting for the purpose of expressing the employer's views on unionization and related matters. Now, the General Counsel says that these types of meetings are inherently coercive, violative of Section 7, and that they are unlawful. She even thinks that certain one-on-one meetings between managers and employees are inherently unlawful. And if the board agrees with her standard, then it will be harder for employers to communicate with their employees about their views on unionization and related matters. It's going to make it more difficult for employers to get their message across to employees, making it all the more important that even before there's any organizing going on, employees effectively communicate that message now. As well, the GC has advocated for what's called the Joy Silk Doctrine, which is organizing by card check, by authorization cards. As the law is now, if presented with authorization cards, meaning that employees have signed cards to ostensibly show their support for a union, an employer generally can insist on having a secret ballot election, which is the preferred method for determining an employee's wishes, a secret ballot election, just like we do in other types of elections. And the GC is advocating for the board to re-implement a standard from the 60s where an employer would have to accept those cards and could not insist on a secret ballot election unless they had a good faith doubt about those cards, which would be a very difficult standard to prove, we expect. And again, making it easier for employees to be organized because they could do so on the basis of authorization cards, not a secret ballot election. Also on the table is the NLRB's joint employer rulemaking. In addition to the judicial type power that the board has to issue decisions case by case basis, the board also has rulemaking power. Under the Trump board, a rule was issued regarding the joint employer standard. The board has now on the table issued a proposed new joint employer standard that would result in more entities, related entities, let's say, or such as a staffing company and a client employer, being found to be joint employers. And why does that matter? Well, joint employers can be responsible for each other's unfair labor practices and for their bargaining obligations and other obligations under the NLRA. So that could have a significant impact on employers if it's easier for it to be established that they are a joint employer with other organizations.
All right. Thank you so much, Michelle. That was an incredibly informative presentation on all of the updates on the NLRB today. While you take a moment to look through the questions, because we got loads of wonderful questions in the Q&A panel, I just wanted to remind everyone that you do have another opportunity to register for a demonstration of ComplianceHR and receive a 1-week free trial. What does the NLRB discussion have to do with employee handbooks? Well, as Michelle alluded to on the last slide, I want to ask you guys, do you feel you have all federally and regionally required union-related policies in your employee handbook? Because PolicySmart state guides are able to cull all policies for you in your organization in any applicable jurisdiction to provide you with those to include in your handbook. And it can also even draft a sample handbook for you. Another good question I'd like to pose is, did you know you need compliant handbook policies in place for all jurisdictions in which your organization operates? Now, that includes where your remote employees may be based, even if you don't have operations otherwise in those areas. So again, if you are interested in a demonstration, I'd be happy to send your information to our panel of experts, and they could sit down with you, walk through your specific compliance needs, and see if our solutions are able to help you out. So I'm going to go ahead and close that poll, and we can move on to some questions. Michelle, are there any that you would like to tackle first?
Yeah, these are all really good questions as I'm looking through them. We don't have time to tackle all of them, but I will tackle some. Do we expect to continue to see state initiatives to overturn right to work laws? That is possible. I mentioned the PRO Act. The PRO Act would do that by operation federally. That didn't get the support to pass in 2022. Employers hope that's the case in 2023. But that is possible that other states could file suit and overturn its right to work laws. Some states, on the other hand, may go the other route and try to pass constitutional amendments to the contrary. So we'll see how that plays out. I have a really good question. What is an issue-free workplace and examples of that? When I say issue-free workplace, in the past we used the term positive employee relations. We still use that, but or union avoidance, but it's really broader than that. An issue-free workplace, no workplace is completely issue-free. That wouldn't be possible, but striving for an issue-free workplace means that the employer is creating an environment where employees are engaged, there's truly an open door policy, and employees don't feel like they need to engage a third party like a union to have their voices heard. So that's what I mean about fostering an issue-free workplace. It's one in which employees don't feel like they need that third-party representation. Let's see. Could you speak more in general terms about the charter of the NLRB? Is it really only there to try to force unionization? That's a great question. You would think by the policies that we see now coming out of the administration and the general counsel that the board's mission is to foster unionization. That's not actually the board's mission. It is intended to be a neutral agency for the purpose of fostering labor peace. That's the mission of the National Labor Relations Act, is to foster labor peace, not unionization, although that seems to have been lost on the present administration. Looking through the I see a number of questions about severance agreements being unlawful. I want to clarify that when it comes to the McLaren decision, they're not saying that severance agreements, the board did not rule that severance agreements in their entirety are unlawful. The ruling was that giving an employee, proffering to an employee an agreement that has overly broad provisions makes that proffer to employees unlawful. So it's not that you can't have severance agreements anymore, or not even that you can't have confidentiality and non-disparagement provisions anymore. What it means is that they have to be more narrowly tailored to accommodate employees Section 7 rights. And there are different ways to do that. And I would encourage employers who are concerned about their agreements to contact Labor Counsel to help them in that analysis. We have a question about captive audience meetings. The GC does have, General Counsel does have a brief to the board on this issue. This issue is before the board, whether captive audience meetings, and the GC defines that very broadly, will continue to be lawful. They've been lawful for the history of the National Labor Relations Act, and we will see what the board does there in terms of their continued lawfulness. But that is before the board. What is an example of a joint employer? A joint employer is two employers that are not necessarily related at all in their structure, like two separate entities, like, for example, a staffing company and one of their clients, where they're totally unrelated companies, but they might be found to be joint employers if they both exercise sufficient control over that same group of workers. And the standard that the board is proposing now would make it easier to establish that two entities like that are joint employers of those workers than the standard is now. And that would make those two entities subject to, they would have responsibility for each other's labor violations and responsibilities if they were found to be joint employers. Hope that answers the question.
A follow-up
Can you speak more about?
Oh,
yeah,
sorry,
go ahead.
Michelle. A follow-up question
let's do the follow-up.
Is great. Is a PEO considered a joint employer?
So it depends on the situation. It's not a yes or no answer. I know it's annoying when lawyers give that answer, but that's really the case. It depends upon how it's established and the control or not that the entities exercise over the workers. So I would encourage you to discuss that with counsel who's experienced in PEOs, and Littler has such counsel. All right, let's check out other questions here. Just looking for questions here that are coming up common. Can you speak more about developing a campaign plan? Well, first of all, the lawyers don't develop a campaign plan, but what we can do is help the entity to ask the right questions of themselves to help them develop a readiness plan, essentially, if there were a campaign, such as what's the tone that the employer that we want to take if a campaign were to hit, if we were to get a position or we're hearing about a threatened petition. What is our messaging going to be like? Who is going to be our rapid response team in charge of different aspects of a campaign? What benefits that we offer are we going to I'm not saying we as if the employer were speaking. What benefits are we going to highlight to employees to show them that this is that we're a good employer, that this is a good workplace, things like that. As well, there are legal issues that arise when a campaign hits, such as I mentioned, whether the unit is appropriate, who are our supervisors as defined under the NLRA, things like that. So also addressing some of those legal issues that come up in campaigns in advance, and that really prevents the scramble when a campaign hits, and allows employers to be ready and not doing that scramble if a campaign were to hit. So it's about readiness. Question: do you feel that the NLRB will issue new guidance on employment at will statements and provisions? I don't think that the GC is going to issue guidance specifically about that, but if the board were to overturn Boeing in that Stericycle case I mentioned and return to the standard that was in place under the Obama board for the evaluation of the lawfulness of employer policies and handbooks, it may very well be that the General Counsel will issue interpretive guidance about that decision, which may address at-will statements. Someone commented the board employees are unionized. That's a good one. Are there limitations to the size of a business to unionize? And there was a related question about any threshold for the size of what's called what I refer to as a micro unit. Generally, you don't have units of one, but short of that, you could have a unit bigger than that. There is an interstate commerce requirement, like a jurisdictional threshold for employers to be subject to the NLRA. So, the employer has to have that meet that interstate commerce requirement in order to be covered. When it comes to a micro unit, it could be a very small number of employees, but again, the board avoids units of one.
And question
I have a question: management is excluded.
Mm-hmm.
Let me just address one more, and then we'll do that one. No, I want to cover as many as we can. We have a question here: management is excluded from the definition of employee under the NLRA, correct? How is it defined? So under the NLRA, the term supervisor is defined by the types of duties and responsibilities that supervisor exercises. It's very important to, just because a worker is called a supervisor doesn't necessarily make it so. The board is actually going to look at what that worker really does, not their title. If you have concern about whether a worker really is a supervisor, I would contact Labor Counsel to do an evaluation about that. As far as managers, there is a term managerial employee. That's not a term that's defined in the National Labor Relations Act. Rather, it's defined in board decisions to refer to those employees that participate in the creation, effectuation of labor policy, like HR, like higher level HR is what that refers to. What was the question that you were going to say, Stephanie?
Absolutely. I was going to say we have time for about one more question, and I'm seeing this last one up here tagged on to the micro unit. Are you seeing any specific recommendations to address the micro unit organizing trend, and are they affecting efforts very successfully?
I think the decision being new remains to be seen if we do actually see a proliferation of micro units. As I mentioned, I think it's more important than ever, because we've returned to this standard, for employers to determine what could be the segments of their workforce that a union might be able to organize under this new standard, and see if there are workplace issues among those segments that could lead them to try to organize. So I am seeing employers focusing more on determining, trying to get a window into what could be these segments that could be unionized, and be sensitive to the issues of those groups.
Wonderful. Well, I think that is all of the time we have today for questions. If anybody has any, additional follow-up questions, feel free to email either Michelle or myself. I'll go ahead and put her contact information back up on the screen here. Again, you will receive an email from ComplianceHR Webinars with the link to the recording and slide deck for this presentation. And in the links panel today, you have a PDF that will tell you more about how to access your certificate for either SHRM or CLE credit. Otherwise, we thank you very much for taking the time out of your day to attend this presentation. And Michelle, you did a phenomenal job telling everyone about all of the ins and outs of the NLRB today. So thank you very much for presenting.
You're welcome. It was my pleasure.
Thank you for using the conferencing center.